Good evening to everybody. Welcome to the today class Law of Insurance. Yes, which is the third year first semester course. In other words, we can say the fifth semester course. And yesterday that we dealt the life insurance contract, and we are dealing over the essentials. And the students are joining one after another. Yes, if any person that could read it, so that I could know that you are with me and I am with you. Yes.
Good evening, sir.
Very evening. Read what I posted on the screen.
Respect people's feelings,
Yes.
even if it does not mean anything to you.
Okay.
It could mean everything to them.
Yes, because naturally the people expect the respect from them. So that's why that people say that give respect and take respect. So that is the thing which will be there. So we are dealing about the yesterday in the class the essentials of the insurance contract, and where the essentials comes, we'll find it. There are four essentials. That is the offer and acceptance, consideration. Third one is competent parties, and the fourth one is the legal purpose. These are the actually the valid contract, which is including the insurance contract also there, because insurance contracts are nothing but the contracts between the two parties. So we referred yesterday, or we dealt yesterday offer and acceptance. There we came up to the adhesive offer and acceptance and adhesive contract. There is the contract of adhesion in nature. Then we are coming at the personal contract by the time that finished up the time, and we stopped here yesterday class. So insurance contracts are personal contracts because there is we can change the nominee. Yes, you can change the nominee, but you have to inform to the insurer that you want to change the nominee. Number one, suppose you want to change the policy from your policy to your policy of yours to your son. If such a thing would be there, it cannot be done. The reason we will see it in the now. Property insurance contracts are personal contracts between the insured and the insurer. Property insurance covers the insured for the financial loss of the property, damage or loss. The financial loss of the property, damage or loss, not the property itself. So whatever the amount of the property which is lost, that much amount would be given over there. But the property cannot be purchased and given to you. If the insured sells the property, suppose the at the time of the damage are going to be damaged, at the time sells the property, the insurance does not transfer with it. So it at that instance the insurance company will not pay it, provided of course if they sell the property which is damaged and he got some of the amount, at that instance whatever the rest of the amount would be like, that will be paid with the insurer. So that's the point. Insurance company will not give the replace the property itself, but it can give the loss or damage happen to the property. The insurance can't be assigned to anyone else without the insurance consent. Suppose the insurance of you are the policy holder, and your policy holder you cannot change to your son. The reason, if there is the life insurance policy holder, of course your age is 40 and your son is 20. At that instance, probability of your son, after not life insurance, let me make the vehicle insurance. That's the same thing which is given over there. Suppose if you taken the vehicle insurance and you are the policy holder, can you change the vehicle insurance of yours to your son? Yes. Anyone? Please give me the answer.
Yes, sir, we can change, sir.
Yes, please. If yes, what is the ground? If no, what is the ground? Tell me.
Sir, if son can pay the money amount,
Mm-hmm.
then we can change into our policy into son's policy, sir.
Suppose vehicle insurance is there because your father 40 years old and you take the care when you are driving the vehicle. But when your son is 20 years old and he goes in the speed, that means probability of the accident is more for the son. Hence, son premium will be high and father premium is low. I am speaking about the insurance of the vehicle. I am not speaking about the life insurance. Are you following me?
Yes, sir.
Suppose if it is a life insurance, your father age is 40 and son is 20, but the father wants to change his policy holder name to the son. At that instance, father premium is more, son premium is less. Why?
Because he is the money earner, sir. Salary
No,
earner, sir.
no. Of course, no doubt at all. Money earner, and suppose if he is employee also, son also employee, and drawing more than the father, then the
That
question
is
here
other,
is, the
sir.
question here is,
Age,
when you age growing, no, probability is
yeah.
more for the diseases,
Yes, sir.
and for the young, probability is very less for the
Yes,
hence.
sir. Yes, sir.
The premium for the life insurance for the boy, the 20 years age is less. The premium to the father is more because probability of death is more there. Are you
Yes,
following
sir.
me?
Yes, sir.
So that's
Yes, sir.
why you cannot change it because it's a person nature. Suppose if you want to change it, it brings to the knowledge of the insurer. Yes, that is what we are going to study now. The insurance can't be assigned to anyone else without the insurer's consent. Yes, insurance consent is must. If property and liability contracts could be freely assigned, then someone who presents a low risk of for the recovered losses, for the covered losses, could buy a policy and sell it to give it to someone with a higher risk, rendering the premium inadequate to cover the greater loss exposure. That is the reason. For instance, a parent could buy automobile insurance for himself, okay, because the parent age is more and he will take the due precautions and he never goes very fast. Then decide to assign the policy to his teenage child who generally would have to pay higher rate, that is a premium, since teenagers have a higher accident rate other than other groups. So naturally, when the youngster will do many accident, and where the old age people they don't go more than 40 kilometers per hour, and even 30 kilometers or if anything comes in front also they will easily apply the brake and that vehicle will not be out of control and imbalanced and they may probability of falling down is less for them. Suppose if they fall down, then the fracture is must because the bone weakness is more for the elder people, the bone is strong in the younger people. That is the reason what I want to say. Yes, on the other hand, life insurance policies can be freely assigned because the person insured remain the same. Suppose if the same person should be there of the same age would be there, yes, it can be transferable. We can change it from one person to another person. Indeed, many people who have acquired a terminal illness have sold their life insurance policy to third parties to get money to treat their illness or to provide care. Suppose the illness would be there. For instance, they will sell their policies to other people because of the same age, those who are rich in money, because they will take care of you till they realize the amount from the insurance company. So that's why they will also sell it. Even the insurance bond which you have it now, you can mortgage the insurance bond in the bank and you take the loan. Are you following me? Yes.
Yes, sir.
Good. So beneficiaries can be changed. Of course, beneficiary can be changed because the beneficiaries those who are there for the nominees in the name, the nominees are there. Because changing beneficiaries does not change the insured risk. Of course, it will not change the insured risk. So there is no consequences of the insurer if the policy owner changes the beneficiaries. Of course, without the consent of the insurer, the policy holder cannot change it because that should be inserted in the document and the document should be changed who are the beneficiaries, but the insurer must be notified before the change has any legal effect. This is to protect the insurance company from paying the wrong person or from being forced to pay twice. So naturally when you want to change it, you bring to the notice of the insurer will record it and he will issue the new bond, and that is the certificate of insurance, and that will be a proof so that a wrong person cannot be paid and the same person cannot be paid twice also. So these are the personal contract in nature. Then the second condition, the essential condition for the contract, including the insurance contracts are concerned, that is the consideration. So here the consideration is the value that the parties to contract to give to each other. So that is depending upon the how much year that you will make for the life insurance and for the car, for the business, for the merchandise, how much the target means the total amount of the your business will be counted based on that thing, then premium will be fixed. So it is why the contract is agreed to. The insurance contracts, especially the insurance promises to pay for the covered losses. So insurer will definitely pay what are the covered losses are there. which are not covered, that he is not going to pay because everything is in white and black there, and that the insured suffers, and the insured promises to abide by the contract and pay the premium. So whatever the premium that he obeyed and to pay, that premium that definitely he will pay. So most non-insurance contracts are bilateral contracts. Most non-insurance contracts are bilateral contracts where the promises that each party make are enforceable by the other party through legal proceedings. However, insurance contracts are unilateral contracts. So that is the non-insurance contracts are the bilateral contracts, but the insurance contract is only unilateral contract because if death is happen, the beneficiary is going to get the booty. So that's why they say insurance contract is one-sided contracts, because the other side is no doubt insurer is there, but the beneficiary is only after death they will enjoy the beneficiary. Suppose if he did not die, but the maturity is over, of course he will get the total amount with some bonus. Where only the insurer makes a legally enforceable promises to pay for the covered losses. So in unilateral contract, only legally enforceable person to pay for the covered losses. Suppose the insured dies over there, then the nominee will file it. The company cannot sue the insured for the breach of contract. So the company cannot sue the insured for the breach of contract. However, insurance contracts are also conditional contracts. If the insured fails to pay the premium, what will happen? Or fails to abide by the contract, then the insurer is not obligated to pay for any of the insured losses. So at the time he became a defaulter, then the insured loses the chance that he should be indemnified. So most non-insurance contracts are commutative contracts. So non-insurance contracts are commutative contracts. Let us see how. The amount of consideration given by both the parties are usually fairly equal. So whatever the amount that you pay to the insurer and whatever the amount that the insurer pay to you, almost all the equal amount would be there. Thus, a contract to purchase a real estate usually requires a payment equal to its value. So when you want to purchase a real estate or the house, that equal value should be paid over there. Otherwise, it will not be, the transaction will not be a valid transaction. The insurance contracts are, however, aleatory contracts. So we'll say because the insurance company must pay only if certain events occurs. Here the insurance aleatory contract means some conditional things only it will be then. Any untoward incident happen, then only it will be paid. Otherwise, it will not pay. Suppose the death insurance is there, or life insurance is there. Sorry. So life insurance is there. If the death is not over there, at the end of the maturity period, he will get the total amount plus some bonus. That's only the thing. So it is the insurance company must only pay if certain events occur. Okay. Suppose if it is a motor vehicle insurance is there. Event occur means accident happen only. Then this contract will be enforceable. Suppose if there is no accident, then again you have to pay the premium and take the insurance for the another 1 year or 2 years or 3 years. If they don't occur, the company never has to pay. Yes, no occurrence, no pay. Even if the insured has paid premium for decades, even he paid the decades also, 1 year, 2nd year, 3rd year, 4th year, 5th year, 6th year, total 15-day, decade, 20 years also if he pay it, okay, it will be paid. But unless until the accident will take place, then only that he will realize the amount from the insurer. So, however, if covered losses does occur, then the insurance company may have to pay much more than it has collected in the premium. Suppose in case the second day after paying the premium in the motor vehicle accident, suppose the motor vehicle is got injured, got damaged, and where yourself driving got injured, at that time you will get the medical expenses to the extent how much that you are insured. Whereas if it is a comprehensive incident, then it will give the damages to the car also. So, however, if losses occur, then the insurance company may have to pay much more than it has collected. Whatever the collected is only one premium, but what they are paying is more because such an untoward incident happened, which is not under the hand of anybody. Of course, some people will also fabricate it. They will make it try to get the from the money from the insurance company. Because I saw one of the two examples real, because that fellow in the construction of a house, he fell down. But actually what they did it, of course, no, he took the natural death. Natural death is having. but they made it while it was construction work is going on over there, and that time he fell down from there and he died. That's why he is one of the mass or group insurance worker over there. So they will claim from the insurance company as if you got injured from the workplace. That's what I want to say is. Of course, there is cases some people want to make it out because they say you are not paying to your pocket. The insurance company pays because such insurance company running the very good profits at the time. What's wrong if you take one drop of from the ocean? So that was their idea. Is it good? Is it acceptable?
Yes, sir.
Yes, sir. Is it not the wrong way that you are claiming the money?
Sir, it is already a contract now, sir.
Suppose if he dies in the house, can you show that he died where the construction is going on? Because there is a
Because
mass
it is
insurance.
already
It's a fraud, sir. It's a fraud.
It is a fraud because actually the insurance is for them, not for the life. Work insurance means when a mason or a casual labor would be there, they should be insured. At that instance, in the workplace, he was injured or died, okay, he can claim the insurance. But if he died a natural death in the house because of the heart attack,
that is wrong, sir.
so that is the fraud that you are giving. So no, one should not supposed to do it. Don't see the today
Yes, sir.
because such money will not hold longer also. That's why the people say easy comes and easy goes, and that money which you will earn with the sweat, your what I say blood and sweat, that's last longer also, and you will feel healthy also. Are you following me?
Yes, sir.
Yes, sir.
Yeah, that is the thing which I want to make it out. And most non-insurance contracts are commutative contracts. That's the way I told you. And the premium which you pay is more when you are old. The premium is less when you are young. But motor vehicle is there when you are old. Premium is less, but the premium is more when you are young because the probability of making the accident is more because of the heart blood. So, thus aleatory contracts are characterized by unequal considerations. So, if the aleatory contracts are such a contracts where the unequal considerations are there. If age is more, probability of death is more, or probability of the accident is less. If age is less, probability of the accident more. Are you following me? Hence, the premium will vary over there in the aleatory contracts which are non-commercial in nature. So, competent of the parties, now let us see. The parties to the contract must be legally competent to agree to them. So, that is the competence of the party. Must adults have legal capacity to agree to the contract unless they are intoxicated, mentally ill, or mentally retarded. And the key requirement is that the parties must know what they are agreeing to do. A meeting of the mind means identity of the mind, otherwise, there could be no agreement. To protect minors, the law does not give them a legal capacity to agree to contract except where specified by law. So naturally, agreement with the minor is wide. So what is the classical case law that what you studied in the law of contract? Yes, the agreements with the minor is wide. There is an important case law that you studied in the first year, first semester. What is the landmark case law would be there? Suppose if we did not give the answer, I can say that you did not study the contract. Sir, we studied, we passed also, sir, we scored 60%, sir. Scoring is different and remembering is different.
Sir, in that case, law that mother will not pay, sir, because of his son is minor.
Is it?
Mother.
Mohri Bibi versus Dharmadas Ghosh.
Yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir.
He has taken the mortgage loan by mortgaging the property, but showing that his age is more than 18 years. So that's why I told you for the minors, they sit on the lap of the judges. The judges are their uncles, maternal uncles. So to protect the minors, the law does not give them the legal capacity to agree to contract except where specified by the law. Of course, the law will specify it, then only the contracts are valid contracts. If not, the contract is void contracts, because you cannot make a contract with a minor, or you cannot make a contract with a drunken person, a intoxicated person, because at the time he doesn't know what is the nature of the work, nature of the contract, or the result of the contract also. So that is the reason they say they protect it. Competence of the parties are very much essential, they say. But whatever the essential supply to the minor, yes, that can be reimbursed, even though he is a minor, because he is enjoying the property. At that instance, the minor, even though, but his legal guardian is supposed to pay from his state, if such a thing comes over there. So that is a case law where we can say whether the minor will be held liable or not. In what cases the minor will be held liable, either in the contract or for the tort. In the contract, okay, he can be exempted, but under the tort, there is no question of minority and majority. That everybody comes in the same fashion. So I will tell you one of the thing. Sir, ఇక్కడ ఇప్పుడు there are two wine shops are now sitting is there and only selling is there. That's why the permitted sitting is there, it will be written over there. సో వాడు అడిగింది అన్నట్టు, సార్ ఈ వైన్ షాప్ ఎంత దూరం ఉన్నది అని అడిగిండు. అయితే వీడేమంటాడు తెలివిగా, సార్ 5 నిమిషాలనే పోగలుగుతావు, కానీ వచ్చేటప్పుడు అరగంట అవుతుంది అంటాడు. అంటే అర్థం ఏంటండి? పోయేటప్పుడు మాత్రం 5 నిమిషాల్లో పోగలుగుతావు నువ్వు ఇక్కడికి వెళ్ళి, ఏది ఇక్కడికి, వైన్ షాప్కి, ఆర్ బ్రాండీ షాప్కి, ఆర్ రెస్టారెంట్కి, బార్కి, కానీ వచ్చేటప్పుడు మాత్రం అరగంట అవుతుంది అంటాడు.
Because he will be intoxicated. No, sir.
He will be intoxicated, and that's why 2 steps ahead, 4 steps back he will make it out. So that is the reason they will say పోయేటప్పుడు మాత్రం 5 నిమిషాలు అవుతాయి కానీ వచ్చేటప్పుడు మాత్రం అరగంట అవుతుంది అని. So that is the way of giving the answer, but don't take the very much, be in the balanced stage. That's what I want to say. So an insurance company has a legal capacity if it is a license to sell the insurance in their particular state and is acting within the scope of its characters. So of course, insurance company, there is a regulatory body will be there, license should be taken over there, like opening a shop. You have to take the license, otherwise you are not supposed to open any business also, unless until you take the license from it or register from that regard. So what is the legal purpose, we will say? The legal purpose, then we will see the legal purpose. Yes, you did not unmute it, that's why I am getting the sound. Yes, I muted. So legal purpose is all contracts must have the legal purpose to be enforceable in the courts, and of course most insurance contracts should do. Yes, insurance contracts, the illegality will not be there because they are a standard form of the contracts. And performance and discharge of insurance contracts. The performance required of the most insurance contract is for the insured to pay the premium. Yeah, the contract is for the insured to pay the premiums, because insured pay the premiums to the insurer and perform any other duty that are required by the contract, while the insurer main duty is to pay for the losses, even such a untoward incident happened, either damage to the property or the death of him, if it is the life insurance, if anything happens over there. Most insurance contracts, such as policies for the property, liability, and health, either property or the liability or the health insurance or indemnity contracts, where the insurance company is only required to the compensate for the actual losses. The insurance company will not give the total worth of the property, but they will give the what is the compensate the only the what actually loss happened to that property, up to the policy limits. Again, suppose if the policy limit is only 2 lakhs and your car is about 30 lakhs, the car 30 lakhs will not be paid by the insurance company. It will pay only the maximum limit, the policy limits which is there, the 2 lakhs or 3 lakhs, 10 lakhs or 5 lakhs, it is agreed. Depending upon the lakhs, the premium will be fixed. If the higher the amount would be there, higher the premium. However, some contracts such as life insurance policy contracts pay the face amount of the policy. So whatever the face amount of the policy, if you could pay it, that much is enough. Besides that, the insured must pay the premium to the insurer. Neither party need to perform until loss occurs. So now the question comes over there. If once you paid over there, and you need not to pay unless it is a regular installments are there. You would once, for instance, when you take the third party insurance or comprehensive insurance, you pay only once per year. That's all. You not pay every 3 months, every 6 months, and every year. Only pay once the premium, that's enough. That is validity for the 1 year. Of course, when you increase the years, naturally you increase the premium also. Besides that, the insured must pay the premium to the insurer where neither the party needs to perform until a loss occurs. So naturally, after the loss occurs, then only the things will come into the shape. Otherwise, no. Suppose no loss would be there for the motor vehicle accident insurance, then no accident, no money paid. Accident, money will be paid. Yeah, that will be. But when the loss does occur, the insured must initiate the performance of the before the insurer is required to do anything. So it is the insured that has to move, make a file and bring to the notice of the insurer and give the complaint also. Of course, he will give the complaint if it is the accident is there of the vehicle. So complaint goes to the FIR will be lodged over there in the respective police station and they will issue the FIR. Then the inquiry will be there. Then Panchanama will be there. Then the all legal procedure should be taken into person. Then the insurance company also called. Of course, they will send the survivors. Then we'll also check the everything aspect. Then we will fix it. Okay, this much amount will be paid in this regard. For the injury, this much amount. For the car, this much amount. That depends upon the coverage that you made the policy. Now, the insurance contracts require the insured to perform the specific things or require certain conditions. Yes, insurance contracts require the insured to perform. Yes, they will put the condition for the insured also. Of course, that will be applicable for the both of the party. But before and after the loss, with the law sometimes categorized as conditions precedent and conditions subsequent. So we are already studied what is the conditions subsequent, what is the condition precedent in the earlier classes. If the insured fails to perform these duties, here insured means policyholder, fails to perform these duties or satisfy these conditions, then the insurance company may be relieved if it is obligation to pay the claim because of the breach of contract. Suppose a breach of contract is made by the policyholder. At the time, he will lose the contract amount, means insurance amount. Suppose you are not supposed to drive your vehicle in a drunken state, but you are fully drunken, and that to be the 2 or 3 bottles, the high concentrated alcohol that you sipped it. At that instance, your contribution for the accident is 100%. At the time, the insurance company try to avoid to pay the damages to you because you yourself is 100% drunk in committing or in making the accident. Of course, accident will not be planned one. If the accident be done either by the mistake of him, mistake of the thing also. But whatever going to apportionment would be there. If the apportionment means if the negligence is 20%, that you are going to get only 80%. Suppose if your negligence the party is for the accident is 50%, naturally you will get the only 50% because his contribution and your contribution will be there the 50% where you could not claim for the insurance company. So these are the certain factors will be taken into consideration. But if you say that the total amount should be paid over there, yes, they will prove that the total amount will be paid because he is not a drunken state and he is having a valid license and there is nothing in the fault of him. And the Panchanam also says the thing at the time he will get it provided. Again, the motor vehicle is concerned, only the vehicle parts, which is a engine or gear oil or engine oil or gearbox and certain things 100% will be there. For the fiber, it is depends upon 60 to 50%. Sometimes 50% will be given by the insurance company. However, in most jurisdictions, a court will only grant relief to an insurer's obligation to pay the claim if the breach is materialized. When there is a breach is materialized, insurer's obligation to pay the insured. Yes, a condition precedent is either a condition that must be satisfied or something that is insured must do either before when a loss occurs and before the insurer will perform, usually by paying the claim. If the insured does not satisfy the material condition of the precedent, then the insurer may be relieved paying them. Yes, the condition precedent should be there. If it is not fulfilling over there, then the insurer company will not pay any damage to the insured. Yeah, some common conditions precedents include requiring the insured to notify the insurer of any loss. Yes, you should not inform it. Property insurance requires that the insured provided an inventory of the losses. Yes, he has to prepare the list of the goods which he lost it. Then disability insurance requires the insured to submit the proof of disability to the insurer. So disability of the insurance requires that the insured to submit a proof of disability to the insurer. So What is the proof for the disability of the insurer should have been proved over there. A condition subsequent is a condition must be fulfilled after an event that require an act by the insurer. So the condition subsequent will happen only later part only. For example, if the insurance company wants to exercise its subrogation rights and sue a third party for the insured cause of loss, then the insurer may require the insured to testify in court. Yes, they have to testify in court before the insurer will come into the step into the shoe of the insured and get the claim from the third party when the third party negligence is more, not more entirely. So insurance contracts can be ended by the mutual agreement. Of course, it can be ended by mutual agreement, but cannot be possible in the murder cases. Why? Yes, why? The murder cases will not be a mutual consent, it will be done in the Lok Adalat. Why? Anyone? Unmute and speak. Because that
Sir,
is the
question once.
insurance conflicts can be compromised either in the local adalat or in the court itself by mutual consent. But why the mutual consent will not be recognized in the murder cases?
Sir, that one is the illegal one, no, sir. That is
It
a
is,
anti-social.
it is anti-social and is the encouragement to do the murder, and it is for the money's sake they will not take an action against the wrongdoer or perpetrator. So such cases, there is no compromise would be there. Compromise only the civil cases are there. In the family cases are there. Mutual consent is there, either to unite together or to separate together. But when it comes to the matter of the insurance company, yes, most of the cases they will be compromised. Is it clear? However, life insurance policy usually have an inconstitutional clause which prevents the insurer from counseling a life insurance policy after 1 to 2 years period. The initial period gives to the insurance company time to check the facts of the application and possibly rescind the contract if it defects the fraud. Suppose if they find the defect in the contract or the fraud would be there in the contract, at the time the insurance company will deny to pay the insurance amount to the insured. However, after this period, the life insurance cannot be cancelled by the company for any reason other than the non-payment of it. So, in other cases of life insurance, it cannot be cancelled over there for the non-payment. No. Or the other than the non-payment of the premium, the other ground would be there, then it can be cancelled. So, this was the thing which I want to share with you in the today class. Now we'll say the other thing is there, and of course, this thing is over. As far as the today's class is concerned, yes, we have dealt it. Yes, what we dealt in today class? Anyone? Please. What we did in the today class? Please tell me.
Contract with a minor is a not a contract, sir, not a insurable contract.
Okay.
And that next I remember is that illegal. That is what murder in case of a murder like that. That contract will be void, sir.
Okay. Next.
Next is the that is if the money difference between the motor vehicle insurance, for the motor vehicle insurance, the money difference between the elder people and the younger people is
Different.
there is a difference, sir.
Yes.
For younger people it will be more, sir.
Yes.
And the chances for accident is more, sir.
Okay.
Accident is more, sir.
Okay.
And for elder people it will be less, sir.
No, if it is the life insurance.
Life insurance also the premium will be more for the elder people, but younger people there will be chances are less, no, sir. That's why there will be premium will be less.
What chances are less in the younger people?
There will be no diseases because they are younger, no. There will be no diseases and causing of death is less. Probability of death is less, no, sir.
Okay.
That's why premium will be less and the amount will be less. Premium amount will be less, sir.
What about the competency?
competency that he should both identity of mind should be there, sir,
Okay.
and no intoxication and the that is no intoxication and should be having the sound mind, sir.
Okay. That means whatever the essential of the contract is equally applicable in the insurance contract. Is it or not?
Sir, yes, sir.
And life insurance is a unilateral contract.
Yes, sir. Yes, sir. Yes, sir.
And non-life insurance is a bilateral contract.
Yes, sir.
Yes. Then what is the alliatory contract?
Alliatory means the after the premium, not premium, sir. The time is over, sir. After the time is completed, there will be a return of the with the bonus. That means
Yes.
having surplus money with the surplus money.
Yeah.
That is
That
the
means
alliatory.
You pay the less amount as a premium. If any untoward
But
instance
we-
got, you will get the more for you. If death is there, your beneficiary will get, means nominee will get.
Sir.
So that is the thing we say, and we will also learn is this contract personal in nature. We cannot transfer it. If you transfer,
Ah,
premium will be changed,
Yes, sir.
and it is an adhesive contract.
And also same party should be of the same age. That means the party should be of the same type.
Yes, yes. At that only you can transfer it, but bring to the notice of the
Notice
insurer.
of the insurer.
Yes, that is a must. So
Yes, sir.
these are the things that we have come to our point that what you have studied. So life insurance policies usually have an incontestable clause which prevents an insurer from cancelling a life insurance policy after 1 to 2 years period. So naturally, when the life insurance company is there, even though he is a defaulter, he will pay with the interest. So one cannot cancel it. So life insurance policy usually have an incontestable clause which prevents the insurer from cancelling the life insurance policy even after 1 year or 2 year period. The initial period gives the insurance company time to check the facts in the application and possibly rescind the contract if it is detect fraud. Suppose the fraud would be there if they detect it later part, because that is the reason we will say obiter, that is oberum fide. What is oberum fide? If I pronounce it correctly,
Utmost good faith, sir.
utmost good
Disclo-
faith. That is a very much important
disclosure
factor.
Disclosure of facts,
Any facts, we should not suppress the fact.
Yes, sir.
Suppose if you are suffering with a chronic disease, you have to say that yes, this is the thing that I do have it. And you should not say, suppose you are an alcoholic, you should say that I am an alcoholic. So either 60 ml alcoholic, 90 ml alcoholic. That also you can say. No sir, no 60 ml, no ideal. Sir, one bottle. Your body will not permit it. Suppose if you take also half bottle after, you will become unconscious. You cannot complete the another sip also. Because body will withstand, no? Are you following me?
Yes, sir.
Yeah. So why I am giving this example is it is very interesting sometimes because if you don't disclose it, nothing but you suppress the fact. So one of the example I will tell you that how I want to know the how far that you got it. So a couple, they are going to marry it the first day after marriage. He thought that he will come with the bottle, a wine, that is the whiskey with a glass, 2 glasses, and he wants to come with it, some soda also there. So thinking that the wife will say, please don't drink it because I don't like drinking. Of course, he is not actually teetotaler. He will not drink. But he wants to make it out for your sake that I sacrifice my drinking to get the favor of the wife. Are you following me? Are you following me?
Yes, sir.
Yes. So he brought the whiskey bottle and he brought the soda and he brought the glasses, 2 glasses, and he come into the room. Then he said in front of the bride. Then he is pouring it, opened it bottle. Then the thinking that the wife will stop him. The wife will stop him not to drink, so that he can sacrifice the drinking from the next day. Actually, he is not a drunkard. Do you know what the wife told at the time? Yes.
Because she is also interested in drinking.
She told, no soda, please. Now you understand. Now this fellow is got shocked because she wants to take on rocks. He was thinking that if she says like that, I will forget it. I will get the favor of her. But when they come to know that the things are very much reversed there. Huh? So my point over here is that is the insurance things will happen over there. The next, because of today that we dealt, what are the conditions should be there and how it can be made. And this is the thank you for the listening to my presentation. And we have the 3 minutes still, so I will show you the what would be the next topic, because that already I put it on the screen, that we studied their rights and liabilities of the insurer and insured. We dealt it on the life insurance contract. We should not say life insurance contract. We should say the insurance contract essential, because life insurance is one of the insurance contract with the non-insurance contracts. Then the personal accident insurance we will see tomorrow class. That is the personal accident insurance. So let us see what is the personal accident insurance in the tomorrow class, and you inform the other people also, so that there would be a good strength would be there, a good participation would be there. That is a boosting factor to me also, and that will help me to give the more information to you rather than giving the shortest way of the information. Anything to be asked, please you can ask me. Yes. Is there anything to be asked? You can ask me.
వాలంటరీ క్లాస్ అటెండ్ చేయడానికి భయపడుతున్నట్టున్నారు సార్ మా క్లాస్మేట్స్.
Why? Oh, this is a record item. No, you can speak me. you can speak me. You can speak me in the, because this is
ఓకే సార్,
recorded.
ఓకే సార్.
Yeah, it will be recorded. Would be there. Then we will see it tomorrow. Huh? So let us see.
Thank you,
Stop making. Then we will see you tomorrow. And
Thank you, sir.
welcome.